14 जेको सेक्शन आहे CRPC जो no appeal from certain summary conviction notwithstanding anything herein before contained and there shall be no appeal by a convicted person in any case tried summarily in which a magistrate empowered to act under section 260 passes a sentence of fine not exceeding 200 rupees. उनखां पोइ जेको आहे 414A no appeal from certain summary conviction under the law relating to price control notwithstanding anything contained in this code or any other law for the time being in force there shall be no appeal by a convicted person in any case tried summarily in which a special magistrate appointed under section 14A passes a sentence of fine not exceeding 5,000 rupees under the Price Control and Prevention of Profit Trading and Hoarding Act 1977 of under any federal law or provincial law relating to price. 415 provision to section 413 and 414 an appeal may be brought against any sentences referred to in section 413 414 by which any punishment therein mentioned is combined with any other punishment, but no sentence which would not otherwise be liable to appeal shall be appealable merely on the ground that the person convicted in order to find security to keep the peace. A special right of appeal in certain cases, notwithstanding anything contained in this chapter, when more persons than one are convicted in one trial, and an appealable judgment or order has been passed in respect of any such a person, all or any of the person convicted such a trial shall have right of appeal. 417 appeal in cases of acquittal. Subject to the provision of subsection 4, the provincial government may in any case direct the public prosecutor to present an appeal to the High Court from an original or appellate order of acquittal passed by any court other than a High Court. If such an order of acquittal is passed in any institute upon complainant in the High Court on an application made to it by the complainant, in this behalf grants special leave to appeal from the order of acquittal, the complainant may present such an appeal to the High Court. 2A. A person aggrieved by the order of acquittal passed by any court other than a High Court may within 30 days file an appeal against such order. No application under subsection 2 for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 60 days from the date of that order. If any case the application under subsection 2 for the grant of special leave to appeal from an order of acquittal is refused, no appeal from that order of acquittal shall lie under subsection. An appeal against it an order of conviction or acquittal under section 354A 376 376A 377B of the Pakistan Penal Code 1860 shall be decided within the 6 months. 418 में इहो आहे the appeal on what matter admissible. An appeal may lie on the matter of fact as well as matter of law. 419 में असां जेको आहे petitions file petitions of appeal. Every appeal shall be made in the form of petitions and writing presented by the appellant or his pleader, and every such a petition shall, unless the court to which it is presented otherwise direct be accompanied by a copy of the judgment or order appealed against it. Procedure when appellant in jail. If the appellant is in jail, he may present his petition of appeal and the copies accompanying the same to the officer in charge of the jail, who shall thereupon forward such a petition and copies to the proper appellate court. Summary dismissal of appeal. On receiving the petition and copy under section 419 and section 420, the appellate court shall pursue the same, and if it consider that there is no sufficient ground for interfering, it may dismiss the appeal summarily, provided no appeal presented under section 419 shall be dismissed unless the appellant or his pleader has had a reasonable opportunity of being heard in support of the case. Before dismissing appeal under this section, the court may call for the record of the case but shall not be bound to do so. Notice of appeal. If the appellate court does not dismiss the appeal summarily, it shall cause notice to be given to the appellant as the pleader, and to such officer the provincial government may appoint this behalf of the time and place at which such appeal will be heard, and shall on the application of such a officer furnish him with a copy of the grounds of appeal. In cases of appeals under section 411A subsection 2, Section 417 Appeal court shall cause a like notice to be given to the accused. उन खां पोइ जेको आहे 423 powers of appellate court in disposing of appeal. The appellate court shall then send for the record of the case. If such a record is not already in court, or after pursuing such a record and hearing appellant or his pleader, if he appears and the public prosecutor, if he appears and in case of an appeal under section 411 subsection 2, section 417, the accused, if he appears, the court may consider that there is no sufficient ground for interfering, dismiss the appeal or may. In an appeal from an order of acquittal, reverse such order and direct that further inquiry be made of that accused be retried or sent for trial to the court of session or the high court as the case may be, or find him guilty and pass sentence on him according to law. In an appeal from a conviction, reverse the finding and sentence and acute discharge the accused, order him to be retired by a court of competent jurisdiction subordinate to such appellate court or sent for trial. After the finding, the maintaining the sentence or without finding, reduce the sentences without such a reduction, and without altering the finding, alter the nature of the sentence by subject to the provisions of the section 106 subsection 3, not so as to enhance the same. In an appeal from any other order, alter reverse such order, make an amendment or any consequential incidental order that may be just or proper. Judgment of subordinate appellate court. The rules contained in chapter number as to the judgment of a criminal court of original jurisdiction shall apply so far as may be practicable to the judgment of any appellate court other than high court, provided that unless the appellate court otherwise directly accused shall not be brought up, required to attend to hear the judgment are delivered, ordered by high court on an appeal to be certified to the lower court. Whenever a case is decided on appeal by the high court under this chapter shall certify the judgment or order to the court by which the findings and order appeal against was recorded or passed. If the finding, sentence, order was recorded, passed by magistrate other than district magistrate, the certificate shall be sent through the district magistrate. The court to which the high court certified its judgment or order shall thereupon make such orders as are conformable to the judgment or order of the high court. If necessary, the record shall be amended in accordance thereof. Suspensions of sentence pending release of appellant on bail. Pending any appeal by a convicted person, the appellate court may for reason to be recorded by in writing order that the executions of sentence order appeal against the suspect, and also if he is in confinement that he has released on bail on his own bond. An appellate court shall accept where it is of opinion that delay in the decisions of appeal has been accused by an act of omission, the appellant or any other person acting on this behalf, order a convicted person to be released on bail who has been sentenced to imprisonment for a period not exceeding 3 years and whose appeal has not been decided within the period of 6 months of his conviction, to imprisonment for a period exceeding 3 years but not exceeding 7 years, and whose appeal was not been decided within a period of 1 year of his conviction, to imprisonment for life, imprisonment exceeding 7 years, and whose appeal has not been decided within the period of 2 years of the conviction, provided that the provisions of the foregoing paragraph shall not be applied to previously convicted offender or an offence punishable with death or imprisonment for life to a person who is the opinions of appellate court is hardened, is disparate or dangerous criminal or is accused of an act of a terrorism punishable with death or imprisonment for life. The power conferred by this section on appellate court may be exercised also by a court in the case of any appeal by a convicted person to court subordinate there, subject to the provisions of section 382 when any person other than a person accused of non-bailable offences is sentenced to imprisonment by court and appeal lies from that sentence. The court may, if the convicted person satisfy the court that he intended to present an appeal, order that he be released on bail for a period sufficient in the opinions of court to enable him to present the appeal and obtain the order of the appellate court. Under subsection 1, and the sentences of imprisonment shall so long as he is so released on bail be deemed to be a suspense. Where High Court is satisfied that convicted person has been granted special leave to appeal to the Supreme Court against any sentence which it has imposed or maintained. It is so thinks fit other that pending the appeal the sentence other appeal against be suspended. Also, if said person is in confinement that he be released on bail. When the appellate court ultimately sentenced imprisonment life, time during which he is so released shall be executed compared to the term for which he is so sentenced.